Welcome back. Let's discuss the legal aspects of this case further. Sli, coming back to you, Senzo Meyiwa, he's the guy who actually left AfriForum.
Yeah.
Because I remember particularly when they brought these 5 guys for, accusing them of his brother's murder, he outright said, no way.
Yeah.
These are not the guys. What has he been telling you so far whenever you've gotten the chance to speak to him?
So we had an opportunity to speak to Senzo Meyiwa, and it's nothing new in terms of how vocal he's been in terms of saying that these guys in the dock, he believes they are being framed, and in fact he's one of those who actually approached Advocate Malisa Latefo to represent the accused in this matter, saying that there is a huge cover-up that's taking place. I think we would have played those bites a little bit earlier on Masego, where you heard him saying that they have a completely different scenario in terms of what happened there, and they believe that docket 375 actually contains the truth. He did speak a little bit more about how there was an argument that took place in the house. He didn't want to go into a lot of detail, but saying that there was an issue around a possible argument between Senzo and Zandile Khumalo, that's Kelly Khumalo's sister, and that they know that from the information in this docket, there was no one who entered the home, and this conspiracy that there was a robbery is all just a fallacy. He actually even went as far as to say that, look, in the time that these people took to make calls, to call high-ranking officials to the scene, they could have possibly saved Meyiwa's life instead of trying to cover it up. He also spoke about the witness statements. We know that there is a woman by the name of Piri who is said to have cleaned the house before the police could actually arrive there, which actually also speaks to the fact that the defense believes that the crime scene was contaminated, and by the time Sergeant Musia even arrived, was there actually even a crime scene to begin with? So Senzo Meyiwa once more saying that he does believe that there is a serious issue in terms of interference with how this trial is taking place, but the fact that we are actually viewing a huge cover-up that's taking place.
We do have some of our other guests actually who are on the line right now, who they are joining us virtually. We do have Magdalene Munsami, who represents Kelly Khumalo. We also do have JP Venter, and we have also a third guest as well, who's a legal expert, Umpumelelo Zigalala. Thank you so much to all three of you for joining us. I'm just interested to know from you, Mr. Zigalala, in terms of en bloc. We're not lawyers, so we don't know what happens. All we know is that en bloc means all together. So what would ordinarily happen if there's 2 cases that 2 public prosecution officers from 2 different divisions of the High Court, the same court, have signed off? What would ordinarily happen in an en bloc? And is this something usual? Does this happen?
Let's remember that at the end of the day, it's the NPA that takes the matter to court. So in preparation for your matter to be at court, you first need to convince yourself and find the evidence that you're going to come back with a guilty beyond reasonable doubt conviction or outcome. Now, in doing that, you're going to read the statements that have been collected by law enforcement officers, further have consultations with them to determine whether they're actually the appropriate persons to go into the witness box. And then after you have done that process, you then say, I'm ready to send this indictment to the High Court or to draft it, so that at the end of the day, I'm able to bring this particular individuals to court. Now, if it happens by whatever measure, which I think would be very unlikely that there are 2 dockets investigating the same manner, then you shouldn't take that matter to court without having consolidated those particular statements to determine a few things. Firstly, do you have the correct individuals in which you are going to charge? But most importantly, are there any additional individuals that you must bring into the fore so that at the end of the day, you're able to try them together? They may be different charges which would apply to all the accused, but at the end of the day, it is much better and much more advisable to bring them all together into one witness box so that when we hear the evidence, it is heard in unison. Now, the Criminal Procedure Act then prescribes ways and manners in remedying that if it hasn't been done before. But we must note that it only limits to the charge and not the actual the actual trial or everything which has to deal with that particular trial. So in this case, it's going to be interesting as to what's going to be the position of the state in terms of saying, if it needs to remedy this type of situation, which at this stage is apparent that it may need to do so, how is it going to do this deal with this particular matter? Are we going to have two trials running separately? If it does, take note that all the witnesses which are going to be heard in this particular trial will have to go back again and be listened to. Once you have done that, from a tactic point of view, you have then opened up your tactic, what the witnesses are going to say. Any things which may jeopardize your case are going to be heard for the first time, then you can be able to remedy it in your cross-examination in the second trial. So it's up to the NPA to fix this type of situation that there is. My personal opinion would be extend the number of accused that are there, especially if those particular accused, you are going to charge them with different charges except those of murder. So if the charge is going to be defeating the ends of justice, then maybe you can go to court and argue that, High Court, please use inherent jurisdiction, use the Criminal Procedure Act, but most importantly, the interest of justice. We want to bring these people here. It's better if we bring witnesses once and for all to hear this particular matter. We do have evidence that we investigated. To deal with the matter of why when this particular dockets consolidated even before we went to this trial is something that the law enforcement officers and the NPA will have to look at as to whether are they really competent to bring this trial, are they really competent to make sure that they're able to bring justice, especially because we have to think about the Meyiwa family in this case. They want closure. And in this case, they're not being provided with the closure. In fact, it is even more questions that they have to ask and really ask, where is the law in order to defend us in situations such as this one?
Let me bring in Magdalene Munsami. Hearing Mr. Zigalala there saying that in his opinion, you need to extend the number of accused that are currently on trial, probably add whatever charges that the NPA would feel they need to be charged with. We all know which accused he's talking about, right, in terms of these two dockets now. So what's your reaction to his opinion that maybe the number of accused should be extended?
Thank you so much. And I just want to say that I think the first thing that Mr. Zigalala says is correct. Let's ask the question as to why those who were present at the scene were not first called to present their evidence and their version before court. That would then give us the answer in respect of the corroboration of evidence, be that forensic or ballistic. Now, I do not want us to take attention away from the fact that, okay, let's add accused, but what does 375 say apart from the names that have been alleged? My discussion with the state prosecutor on Thursday, if I'm not mistaken, and my application thereafter for access to the docket does not confirm anything until I have access to such docket. So I would then want to believe that the basis on which Mr. Zigalala is placing his position in terms of adding it is either on the basis of confirming that indeed there are accused in 375, especially on the issue of defeating the ends of justice. Now, I've said this before. There should have been an issue that was raised. If, for example, Defense 1 to 4 had raised 4 or 5 months ago that there was the 375 docket, why then was that not a point that was raised in limine, including jurisdiction at the onset of the state presenting its sketch and outline of the trial? The second issue is that there's no issue in terms of consolidation, but how do we test the evidence? Because the evidence, remember that here we're dealing with eyewitnesses in the house. And the issue that there are confessions creates a dichotomy in respect of the accused. So is the trial focusing really on the accused first, relinquishing their guilt or their innocence, and then understanding what does 375 mean? The implications of 375, in my understanding from the state prosecutor, is that they are going to consider the docket and then they will revert to me as to the veracity and authenticity regarding the 375 issue. My understanding of the 375 issue, however, is the fact that there was such an effort made, a submission that was made by Defense 1 to 4, and that such was never given any light of day. Now, to this day, if there was a 375 docket, the first thing that would have happened before 636 would have been that my client and the others that are implicated in such a docket, of which I have no access or information, would then have to be called by the police, would then have to be charged as accused. This hasn't happened. To date, the state maintains its position. My client remains a witness and not a suspect. And when that then comes to the fore, then we will have to consider, they will have to then consider this 375 and whether it is consolidated. And I raised this in the past regarding its consolidation. That really, and yeah, so that is a position. Thank you so much.
I still want to come back to you. So they've had the en bloc meeting after deciding that they needed to meet with the National Director of Public Prosecutions, obviously to just find out what's going on with two directors of public prosecution citing two different theories. Have you heard anything from the state? I mean, we're going back tomorrow, so that means they've had this whole time to meet. Have you heard anything from the state yourself in terms of them possibly thinking of calling your client anytime soon? I'm not sure if Advocate Munsami can hear me. I'll try and get back to her with that particular... Okay, there you go.
Hello? Yes. Yes, look, I haven't heard back from the state, but I did speak to the state. I did send through a letter for access and regarding this situation as it stands. They have informed me that they will revert to me as soon as they have established the position regarding the docket, and I anticipate that they will respond accordingly.
Let me come to Mr. Venter. You're the head of criminal department in Ulrich Leroux Attorneys, right? So I'm just interested to know from you guys, or from you as an expert, as you've been watching this case, do you think that South Africa might see these 5 men accused walk out with no charges and possibly sue the state for wrongful arrest?
Good afternoon. Look, as far as this trial is going at this stage, there is a possibility, especially now with this docket 375 that has also come to light. We must remember at the end of the trial, logic must dictate what happens. And that this other docket does not necessarily mean that there is a cover-up, but there is a possibility that it might create doubt at the end of the day in the judge's head, or when the judge needs to decide what's going to happen or what his judgment's going to be in this specific matter. There is, in general, we would like the police to investigate more than one angle. We wouldn't want them from the beginning just to have one mindset and stick to that mindset and not consider other possibilities. In this matter, we have now those two angles that have been investigated, but it seems like it went a little bit further than just investigation. I listened to the interview of Advocate Harry Nell on Friday, where he said there was an indictment actually issued as well in the docket of 375. But it was not signed, so that is why they decided not to prosecute on that specific docket. Well, for the state already to draw up an indictment with charges against other accused people or persons must create some sort of doubt, because the prosecution must have gone through that docket and already decided, okay, there is a prima facie case for us to prosecute, and otherwise they would not have drawn up an indictment in that specific matter. That, with the evidence of Mrs. Mapiri that has been cleaning the scene, which is also already very suspicious, plus some of the, to put it in inverted commas, incompetence of the witness that's currently on the stand that keeps on forgetting certain aspects, why he did certain things. That might create a lot of doubt at the end of the day, which the accused might have to go to the accused at the end of the day.
Mr. Venter, I want to stay on the topic about Ms. Piri apparently cleaning the crime scene to conceal evidence of people being intoxicated with alcohol, etc. What do you think about what's come out in terms of how the scene was handled? Of course, finding out that there's 2 dockets has already made people have doubt. But, what's been coming out right now in terms of how the scene was handled, I think, is also something else that's concerning.
Yes, indeed. One would have to ask oneself, if such a horrible incident take place, such an unfortunate incident as that took place here, why would the first thing that comes to mind is take away alcohol, show that there's no alcohol? If this was outside robbers that came into the house, what does alcohol have to do with it at the end of the day, whether the people inside the house was intoxicated? Why would you try and hide that from the police if it was somebody from the outside? Robbers, like I said again, that came into this premises. It is quite mind-boggling to me, to put it that way, unless the alcohol actually plays a role in the death of the deceased in this matter. That would motivate somebody maybe to hide this specific alcohol.
And that would definitely still be defeating the ends of justice. I'm going to ask you all to just stay with us for a little bit. We're taking you to a short break. Don't go anywhere. We continue with this discussion. And as promised, Manqoba Mkhunu will be joining us in the next segment. Stay tuned.